Hello, this is Mr. Zhang from Visa in Korea. Today's lecture is about it's a part of our Immigration Act, right? Immigration Act. Immigration Act is there are the several articles on there, and but as far as I know, except for the E-9 visa holders and the most of the foreigner, they don't know about the very important some of the rules, right? So the lot of the foreigners have focused on the visa change and extension and what is the requirement and what is the process like this, and they're just focusing on them, but there is no any kind of immigration education for foreigners because this is a very important. And if you violate and one of the Korean immigration law or some criminal the law, and very difficult to change your certain like a F2 or the F5. So the one of those things are, you know, some parts need and foreigners and living in Korea and their the effort and keep the Korean law, but there is a one very important obligation and the regulations on and the Immigration Act is I will explain about that, but it's Article 19 of Immigration Act. So most important thing is why you have to know that, because this is obligation for the employers. But if your employers violated the one of the Immigration Act, it affects and your status of stay. That is the main reason that I make this the video, because most of the aliens and the foreigners living in Korea, they just know that the what is the requirement for the visa change and extension. But if it's something that happen for your employers, but if you don't know, I said already, and they just violated some of the immigration law by the employers of you, but it affect you your visa change or extension. This is very critical things, but and there is no any other information about that. So I already made it Korean version of obligation to report by employers of aliens. But you must know that if one, at least one thing has changed on your current company, you must let your employers know that, because it is not your obligation. But I explained already, if your employers violated one of the immigration law, it affects you, right? It affects you, and whenever you change or extend your current visa or whatever, especially a huge impact on F2 and the F5 when you apply for that, because most of the foreigners living in Korea and staying in Korea, their final destination is F5 permanent residency, or some kind of a middle stage, right, to stay in Korea more comfortably. It is one of the visa type is F2 residence visa. So as you know, F7 and also F299 need some of the things to be, you know, like capped and or followed by the Korean law or immigration law. This is mandatorily required for the all kind of F7 and F299 as well as F5, all F5 visas. So this is a very critical, it's a very important. So that's why I just made this movie. It is not your obligation, but your employers. But if at least one thing and has changed, you must let your employers know about it, because if not, huge impact on, you know, like refusal or rejection of your application for any other the visas or extension, right? Good. Let's start. The most important thing, Article 19 has indicated that obligation to report by employers of aliens. It means some of the employers hires some of the foreigners, and in this case they have to follow some of the rules. There are lots of rules, but this is very critical, so that's why I just let you know that, right? And Article 19, the paragraph 1, an employer, your owner, right? Owner, the company owner of an alien, right? And the alien means is a foreigner. I just followed in the English version of Immigration Act, so just written in just alien, but just to set that the foreigners, right? Good. An employer of an alien, some owner hires and hired, right? And or employer is hiring the foreign national. The granted status of state that entitles the alien to engage in job seeking activity. This is a little bit. I think this in Korea is a 취업 활동, and in this English version is called job seeking activities. But actually, the job seeking is the D10, right? So that it should be and change it to some kind of a working activities, right? Working activities. But you know that the presidential, the decree article 23, I said it several times. There are some of the visa type, especially F2, right? And that kind of visa, it is there is no any kind of restrictions to the work on some kind of jobs, right? So so mostly that one exactly affect on the E-1 to E-7 and the visa holders, right? Some of the employers of E-1 to E-7 visa holders. So F2 has some no restrictions. So it's on the working, right? So that's why this Article 19 has focused on actual working visa holders in the company E1 to E7, right? So, but it has written in the job seeking, but focused on working activities under Article 18 and the paragraph 1. It shall report any of the following circumstances to the head of the competent regional immigration office, right? Within 15 days. The most important thing is if something's happen in your company, right? Your employer and shall report to immigration office, right? And when? Like within 15 days from when? Date of occurring things to be reported. Okay, so the first one, which kind of situation happened, and your employer shall report certain and the information to immigration office as a employer's obligation. The first one, he or she has dismissed. It means he or she is foreigners. Like a E1 to E7 visa holder has dismissed the alien, or alien has resigned or died, right? This means if foreigners as it has dismissed or just resigned your company, right? It means the dismissed is means is A company and the B and the foreigner. In this case, is forced to the resign. That is the card dismissed, right? The first one dismiss, right? This in Korean is a haggle. Just some things that happen to the foreigners working at a company, right? And some of the rules and this companies and the company's rule, right? So he like a foreigners sometimes and missed exactly like like a working hours and just without the permission and the foreigners just go back his home or to take a rest or something without any permission. And if and the meets and some of the dismiss and the requirement, right? In this case, the company the may dismiss and the B and the foreigner, right? In this case, or voluntarily and B because wow, I just try to work hard, but I cannot follow this company's rule or some oh wow, this company isn't met my time, it's not fit for me. In this case, the resign by your own self, right? Or if in the foreigners died, right? This is who shall the report in this case employer. Okay, the second one is and the employed alien becomes unknown, right? It's a company hired and the B and the foreigners, but I try to contact him and where are you? And just he or she disappeared. In this case, right? They have to and the report to the immigration office. The very important thing is number 3. He or she has amended the important term of the employment, right? So in this case, in the employment contract with the alien, right? And what does that means that A company and B, the when apply for the E-1 to E-7, they have to make some of the working contract, right? There is some of the company name, etc. or something. The contract, and there are lots of information on that. So some of the very important terms are changed in this case, and the employer must and the report to the immigration office, right? Who shall the report these things happen? Hmm? Who? Yeah, this is the employer, not the foreigners mandatory and the things to report if one of those things happen. But I said already. So the important thing is, yes, everybody understand in number 1 and number 2. Yeah, so most of the person knows it, right? And the second one, unknown foreigners, and nobody knows where the foreigners is there, right? In this case, then I have to report to the immigration office. The most important thing is number 3. What is the important term of employment contract? Important terms of employment contract. So the first one that there is the project decree has indicated that some of the I just check this one more time for this case, right? And don't have to do that. Okay. So in this case that if the one these are presidential presidential decree Article 24. And in this case, the first one, what is the important terms of employment contract? The first one, and your working contract period change. For example, but actually first you got the E-7, like the working contract is September 1st, 2021 to August 31, 2022. In this case, right? But if that and the working contract is changed, like a September 1, 2021 to like a July and 20 or 2022. In this case, and your visa is valid until August 31st at least. But if it's changed in a working contract period, like a like a 1 month more earlier, and foreigners and the employers on working contract in the period has a certain like a 1 month. In this case, right, the period change you must report, right? Who? Employer. The second one is what? Second one is if your representative and changed, and another one, and the company name changed. Which one? Another one. Yes, and if your company is relocated to a new place, right? Even like 5 meters or 10 meters, it doesn't matter. So it means the location is changed road name and room number, like such as like a room number of your company. If it's a relocate and you are current company into the new one, you have your employer shall report it to the immigration office within 15 days. So what is the 15 days? And the representative changed and the name in the A company's representative name is Mr. Zhang, and but it's changed to Mr. Kim, like September the 1st, 2022. In this case, but mostly in the registration date, right? And your registry office, and there is some of the registration and for the corporate, so to change the name and need a registration at the registry office, right? In this case, it's confirmed, and it shall be reflected on your business certificate of your company. Yeah, in this case, based on that issuance date, right? Recorded date, and from 15 days. This is very important. The company name change is the same thing. If your company is a corporate, is a need and a registration of the registry at the registry office, after that change your business certificate. In this case, and the date of renewal of your business certificate into 15 days. And the company name change is the same thing. But if it's a corporate, like I said, I think, but if it's a private company, in this case, just at the time of business certificate is renewal, right? In this case, we have to report the 15 days from the date of renewal of your business certificate. The relocate is the same thing, and if the company is relocated into the different place, if your company is a corporate, then need several steps to be completed. So in this case, finally, and listed on your business certificate is a business certificate is 사업자 등록증. And on that date, the renewal date, and from the 15 days, we have to report it. And in this case, right, and you can report and the gathering some of the document and send it to fax is no problem. But after 15 days, you have to visit the immigration office, and you have to check the investigation about your any kind of violation of the immigration law. So after 15 days, it is to make some problem. So that's why they made this in the movie, right? So okay, I will just clear for that. And there is some of the article on the Immigration Act, right? Employers and the hiring some of the foreigners, the holding E-1 to E-7 visa, right? In this case, most and the report some of the very important change into immigration office, right? The first one, and like the company and like dismissed and the foreigners, right? Or just foreigner itself just resigned by himself or died. The secondly, and nobody knows where your hired foreign national live and cannot contact him. In this case, right? Then I have to report. The most important thing is number 3, and if there is any kind of important terms of the employment contract, and your company shall report to the immigration office. What is the important terms of employment contract? I said the first one, working contract period is changed. And secondly, representative changed, and the company name changed, and relocate your new office, right? In this case, and then you have to the report, like you means and your owner. The employer shall report this information to immigration office, and within 15 days from this, some of the region happened, right? So I just explained what is the starting date. Is based on business certificate renewal date to 15 days. You have to report it. So if in this case, if you report within 15 days for the very critical, very important, and the information has changed, in this case, you can send the kinds of information document into through the fax. But after 15 days, there will be a huge and problems and your company as well as you, right? So before the 15 days and it happened, that kind of very critical, then very important information changed. You and the foreigners, it is not it is not your obligation, but you must let your employers know, and that information today I lectured you and must report to immigration office through your employer. Okay, so today is my lecture's topic was obligation to report by employers of aliens, and the Article 19 of Immigration Act. This is a very, very important that employers must report some of the information into immigration office. If not, yes, and immigration may give fines, gives and the fines for your employers as well as you. Why? For example, the company changed, his owner changed, and you were still working on it, right? It means what happened? You were working and the same company name and same business and the registration number, but different owners and working. So you violated, your employer violated immigration law that I said already, and the prejudicial decree, right? And the article 24. So it affected you, right? And working because of the violation of the immigration law through your employer, but it affects you. So you must listen my lectures, right? Knowledge is power. Okay, good. Thank you. And we can talk further with more valuable information on Immigration Act. See you next time. This is Visa inquiry, Mr. Zhang, and you can contact me through my cell phone. Okay, thank you. See you next time. Bye bye.